Thank you, sir. Okay, welcome to the April 5th regular meeting of the Durham Planning Board. Our first item this evening is roll call and determination of a quorum. We have a quorum. We have Mr. Tyler Hutchinson, Ms. Juliette Kaplinger, Mr. Alan Purinton, and myself, John Talbot. And so we do have the quorum. Do we have any amendments to the agenda? Seeing none, we'll move on to item number 3, acceptance of the minutes of prior meetings, this one being March 1st. And just as a note, we did not have a quorum for the February meeting, and so there were no minutes from that meeting. So March 1st minutes, George provided them. Anyone have any comments on the minutes? If not, I'll be happy to accept a motion.
I'll move to accept the March 1st minutes as presented.
I'll second.
It has been moved and seconded. Any further discussion? Seeing none, raise a hand if you're in favor. It passes 4-0. Okay, the next item is informational exchange on non-agenda items, starting with town officials. So, Mr. Thabarge.
Just an update that, as you all know, the town meeting approved amendments to the land use ordinance and to the zoning map. I have finished updating the land use ordinance and the zoning map and sent it to Kimberly to be posted on the website. If you would like hard copies of those documents, you please let me know and we can provide them to you. But they should be posted on the website tomorrow or Friday. So just want to give you that update.
Are they expandable will they be expandable on the website?
Expandable in what way?
Larger version.
Of the map?
Yeah.
Well, you like any document on the website, you can zoom in.
Zoom in.
Sure.
I was actually going to ask if I could get a whole new set of the ordinance, just because I think mine is actually outdated compared to some others, and then with the additions.
Basically, I would provide the current zoning ordinance to any member who wants it.
Yeah.
It will be available on the website. You can download it onto your computer.
Yeah.
And I can also give you a hard copy
I'd
if
like a
that's
hard
what you like.
copy,
You'd like
please.
one hard
Yes.
copy? Anybody else?
I would, I guess. I've never.
Okay.
And also, it's a good point about the map. So I know we can zoom in. I'm sure you'll get a printed one like this.
Yes, yeah.
For in here.
Right now, all I can produce is an 11 by 17. That you have to go to a special printer to get something like
But
that.
we'll have that in here. And
We
then,
will.
yeah, if I could get 11 by 17 with a hard copy of the ordinance, I'd appreciate that.
Sure.
Don't give me a hard copy, George. I'm good.
Okay,
I'll be fine, thank you. Anything else?
that's it.
And then-
Mr. Chairman,
then-
can I, as an alternate, may I ask a question?
Oh, you may participate fully. I did not recognize either you or Ms. Torregosa, who just as alternate members, but you can do anything but vote.
Are there any applications that are for the board that are affected by this change? Or
I do not believe so. The
So-
only application that's before the board is the Deer Creek Crossing subdivision. And I don't think any changes were affected there.
So moving forward, this is the map that we'll use to review any
Yeah.
new applications.
That's right. And plus, I would also point out that the application of Deer Creek would be vested, and therefore you could not apply the new zoning to that,
Grandfathered in,
even if
sort
it did affect, because they had applied and you had done substantive review before it went into effect.
Good question.
Yeah, that's a good question.
Okay, George, anything else?
Nope.
I think the next one is any residents who are here for public comments. Non-residents? And I would say that I'd like to thank George, the Conservation Commission, and actually a lot of people in the town of Durham who participated on the two land use ordinances that we voted on and passed on Saturday. So thank you to everybody for that effort. And so we are now, the next thing is continuing business Deer Creek. And please introduce yourselves and an address.
Address, you want my home address?
Brooke.
I'm Charlie Burnham. I'm with Grange Engineering from New Gloucester.
Yeah, and Jack Dowdy from Freeport.
Okay, thank you. So I understand that you are here to request to be tabled, is that?
I think that's pretty much the extent of
question?
it. We're still waiting on the Army Corps permit. I don't think it's intelligent to print off a whole nother set of plans until I hear back from them. Because if something changes on that, then it's a whole nother set. So I just figured, let's just hold off.
Any prognosis from, okay,
I've had one conversation with her. She's yet to get back. So we've had, I think it's like email, wait 3 weeks, email, wait 3 weeks. So
okay. So we did, as the board, we need to do two things tonight. One is vote to approve or disapprove their request to table. Then the other one is to give a deadline to have, to get to finish this. And so I guess the first vote would be on their request to table it. Any comments? If not, a motion?
I move to accept their request to table.
A
Second.
Have-
Yes, the only, as you had mentioned, you talked about a deadline for that. Should that be included within that motion?
Yeah, we probably can. We can do both, kill two birds with one stone. I'm okay with that.
What are the repercussions for the deadline, like in our ordinance and all of that?
So as I pointed out in the agenda notes, once you make a determination that the application is complete, a clock starts. And that gives you 60 days to make a decision on the application. This was determined complete in, wasn't at the February meeting, it must have been at the January meeting, March meeting.
Yeah, it was a March
meeting.
meeting.
Yeah.
I watched that on television today.
Yeah, so there were it was 60 days from that point that you would have to make a decision. So if you're going to go beyond that, then you need to get the applicant to agree upon a different time limit for decision.
In my thought would be that we make it a sufficient time that we don't have to keep doing this every 2 months.
Correct.
Because they can always wrap it up and come in and get a decision.
Right.
If we give them 6 months, they can come in next month if they have everything they need to
Right.
get a decision. So would you like to amend your motion, please?
I would like to include within that motion that, I'm trying to think where I go.
It would be to establish a new deadline of 6 months from the date of completion, determination
I
completion.
was gonna say from today, but it's 6 and 1/2 dozen other
I
probably.
was looking October.
So 7 months would be our October meeting?
Again, I think the wording should be to extend from the determination of complete application 6 months instead of 60 days.
Okay, it has been moved to approve their tabling.
And just make sure that the applicant agrees to that.
Is that
They're shaking their heads, yes.
I'll second that.
Okay, so we have a motion and a second. Any further discussion? If not, please raise your hand if you approve. And if not, if you do not approve, raise your hand. It looks like it passes 4-0. Thank you. And hopefully we see you long before end
Right,
of September.
yeah, I
just
think,
thinking that
I
too.
think from the
Yeah.
sounds of the last conversations is the peer reviewers signed off on all of our changes except a detail I got to tweak.
Yes. that's
Survey, subdivision's done,
Yep.
fire chief signed off.
Right.
So I think this is pretty much the last
Okay,
box to check. We can do this all at once.
hopefully you can get that and we can make a decision.
Great.
Thanks, guys.
Appreciate you
guys.
Happy Easter to you.
Yes,
happy Easter.
Okay, so then the next thing was other business. So we did, congratulations to everyone. We did get the resource protection approved and the verbiage on who approves private roads becoming public. So I guess I asked George, thoughts about what types of ordinance changes we would like to take on in the coming year. And so interested in what your ideas and what you think are important that we need to do, recognizing there's, as we learned this past year, there's a limited resource available, time and otherwise. And then we had been talking, and I guess I'd let George talk about some of the, you met with the town manager and resource guy to talk about ordinances changes yesterday in general or anything specific?
What might be helpful is just to start with a quick recap of how we got where we are today, which is the adoption of the 2018 comprehensive plan back in April of 2019. And so the first step of implementation of that new comprehensive plan was to do an overhaul of the land use ordinance. Some of you board members were around from the 2016 version, which was just almost indecipherable. And it was just totally disconnected internally. Just had been put together by people that didn't put a lot of time and effort and money into it. And that's the product that you get. So it was outdated, still 1970s vintage subdivision regulations. And so I think it was in the next step was to do an overhaul to consolidate. And the other problem was that you had certain ordinances that were just like out there and nobody even knew they existed, like a mobile home park ordinance. Code officer didn't even know that that was there. So we pulled in the gravel pit ordinance, the historic preservation ordinance, and the mobile home ordinance and the addressing ordinance into the land use ordinance, so that all of the ordinances that you need to know about in terms of land use issues are all in one place. So that was accomplished in the ordinance. And the other thing we did was to update the subdivision and site plan review regulations to be what most of the towns in southern Maine use to review subdivisions. And you've seen some of the changes that's made in terms of the recent review of this subdivision. So that has all been accomplished. And when we were doing that, we made a conscious decision not to bring up any of the difficult land use issues, because just getting that, fixing the broken framework for reviews of projects was really important. And that was overwhelming to do the whole ordinance at one time. So we put off dealing with home-based businesses, we put off dealing with roads, some of these very difficult and contentious issues. You consciously made a decision to hold off on that. Then you undertook to go and address some of these issues. So you've been looking at updating the road standards. You looked at home-based businesses. We tackled the resource protection recommendation of the comprehensive plan. So, but frankly, what happened was, I think, because a lot of factors like the pandemic, things just got really, really disconnected in terms of the policy development framework of the town. So over the last year, I think you've seen the difference where the Conservation Commission, the Planning Board, and the Select Board have all been working together on these difficult land use issues. And I think the last town meeting a year ago was a result of when you don't have that. And this town meeting was an example of how it works when you do have that kind of coordination and communication. So what I'm wondering is that, and I think really the last few years that it's just been very difficult to get anything through town meeting. And so there are a number of issues that are still out there, including the ones that I just mentioned. The comprehensive plan has recommendations in a number of different policy areas like housing. This issue with the state's affordable housing law still being in a state of flux, that's obviously an important issue to address. But just from my perspective of having done this for 40 years and seeing what towns go through, I was in Falmouth when the first cell towers started coming in. And this town still has no regulations dealing with cell towers. And under the Federal Telecommunications Act, and I'm not sure, Ann, if you're familiar with some of those requirements, but basically, my concern is if you get a cell tower application, I do understand you've had one here in the last 5 years or so, but if they come in and they're contested without any ordinance regulations, you're basically giving them they get their approval. Because under the Federal Telecommunications Act, you could not deny a cell phone tower on the grounds of it's not in the scale of the community. So I'm really concerned that you have some exposure on that. And then the other one that's come up even more recently that is really coming is the issue of the solar farms. Those are proliferating all across the state. And they typically go in wide open fields where they have maximum exposure. And we have had one project that's being explored in Durham, not in an open field, but again, you have no standards. The only thing you would be able to apply would be the conditional use criteria. So those are a couple of important issues. And then the other thing to look at is how much capacity do you have in terms of researching these issues, putting them through a public process, getting them through a town meeting where you have 50 other warrant articles. It's a very, very difficult prospect to try to do this type of work in a town meeting format. But that's what you have, and that's what we'll have to work with. So it's just a kind of a framework of understanding of what some of the dynamics of the process are and some of the issues.
Mhm.
200 words a minute?
Mhm.
Other thoughts on ordinance changes that we might consider? So if I understood George correctly, you seem to be leaning towards solar panels, cell phone towers, affordable housing is out there. You know, we didn't come to a resolution on that, and you know, there's a lot of changes afoot on that. So it may impact how quickly we need to move. And then a potential one that I have is, and although I don't think it should be an issue, we've talked a lot for 2 years in the town about changing our fees for filing for zoning changes or plans, and also building permits and other things. So just the fees that were, and there was a fee proposal from the code enforcement guy, and we'll talk about it in detail later. Any other changes you'd like to see to the land use ordinance, and then we can beat on these 4 or 5 or 6 or whatever we come up with.
Well, someplace, because I've been looking at the fee schedule too, and I know that Alan Plummer, our CEO, went before the board and he was expressing concerns about cell towers and solar arrays, but there's nothing specifically in our ordinances about that. But as I was reviewing, I didn't see anything specific in the ordinance about where fees would be. And the only place that I could find it was based on information that the CEO had actually published, saying when permits were required and those not required, it was not in the ordinance anyplace, unless I'm totally missing it. So
What kind of fees are you talking about?
any fee, electrical fees, plumbing fees, any fees that were customary fees.
Because there are fees, as you remember, throughout the land use ordinance for various things like a conditional use permit.
Well,
But the electrical permits, the plumbing permits are handled by the state plumbing code. Building permits and electrical permits are done through separate ordinances. So those are in ordinances. The fee schedule is still set by the select board.
Right. And if an individual, like I was, okay, where is a fee schedule located? I don't know where it would be located, whether it would be under the CEO's identification somewhere. I know it's not an ordinance because we pulled it out last year.
Right.
As to being specific. But there was a lot of hesitancy by the board, the select board, on addressing some of the concerns that Alan had. And I don't know whether that's because it wasn't backed up by a specific ordinance. That may have been their rationale.
What are the issues with the fees in general?
The fee, in general, the reason it was taken out of the ordinance because the fees basically were not up to date. They weren't consistent with other towns. When Alan did a thorough investigation of it, we weren't even coming close to a minimum of what other towns were.
Okay, so that's a pretty
So,
big issue,
One
right?
of the requests actually from the budget committee was that these fees should be covering his salary.
Okay.
That isn't the way he backs into it. I think he actually went through and did an analysis of different towns and where do we stand associated against those other towns. So I believe that he was going to present something to the selectmen. He actually did. They wanted him to come back and they only wanted him to present to them the customary fees out there and not addressing cell towers or solar arrays because we didn't have an ordinance to back it up. That's my interpretation of why they didn't want to. address those.
And I, again, having nothing else to do this afternoon, I watched it on TV, and I think that's exactly, they were fine with changing if you will, the known fees. So electrical permit,
Right.
building permit, whatever it may be, the code enforcement proposed an address fee. So, if you build a new house, you get a new address. And that's the way he explained it. It's much more complicated. It's a couple hours worth of work because it involves going to the site, managing distance between houses. And there were some others that I can't, the cell phone, right now, if there's a cell phone tower, all we charge is $75
Well,
for.
aren't all of those under like a conditional use or whatever type of permit they're going for? Or is it specific to the use
This is, well,
for the fee?
there is no fee for cell phone towers right now.
Well,
He's been-
because we don't have an ordinance.
Yes, but
But that was a bad example. Like for any type of these projects, subdivision's different, but any type of conditional use, it's one flat fee, right? It's like the same regarding the use.
Yeah, one of the things that he had run into was if he was going in to do an electrical inspection, he would show up to the site, and these are supposed to be licensed electricians that are performing the work, and he would actually go in, and if you looked at in a bathroom or a kitchen, they should all be ground fault, and he would actually go there, and they weren't ground fault. So he would have to basically not approve it, and eventually he would come back.
Mhm.
So I think he was looking at, should he be charging for that extra time? I don't know.
And I think our mission would be, first off, I think the authority exists that we don't need to make an ordinance change. And towards the end of the discussion on YouTube, the town manager was tasked to get with you and code enforcement, get with the town attorney and take a look at the change in 2022 when an ordinance passed about fees, to take a look at that and see what powers authority that gave the selectmen to designate fees. Is the verbiage general enough that a new fee like addressing or could be applied and developed, or does it require a change to an ordinance somewhere that says the selectmen have the ability to establish new fees?
So I think there are three different levels of analysis for that question. So the first is clearly the fees that used to be specified in the land use ordinance. So for example, the ordinance used to say the application fee for a conditional use permit is $50. That goes for the planning board review. It used to talk about subdivision applications. So the amendment in April of 2022 said the fees will be established in a fee schedule adopted by the select board on an annual basis based on a comparison with what other towns are charging and the actual cost to the town of providing the service.
Mhm.
So last June, the select board actually, remember at April meeting, that change to the land use ordinance was adopted. In June, the select board adopted all the current fees that were in the ordinance, just to make clear that, yeah, you can collect them now. You have to pay them. And then I provided the report that you're referring to the select board and interim town manager last August. And with all of the rollover of town manager and everything else, it kind of got lost in the shuffle. And so that was a comparison with 6 other towns that are comparable. And Durham's was mid to low, the lowest. Some of the other towns were charging double for building permits. And the main revenue source is not subdivisions, as you have one subdivision application in the last year. It's mainly building permits. And so some towns are charging like $2,000 for a building permit. Durham's around $800.
Yeah.
So, and as John pointed out, or Alan did, there's at least 4 inspections going out there. And depending on how much he has to keep going back, it's a lot of time and money and a lot of risk in terms of liability issues. So the town manager yesterday you brought that up to his attention, that you interpreted what the select board had directed was that the town staff was to get a legal opinion. So again, back to my original opening, which was there are 3 different classes. Clearly, what was in the ordinance and is now in the fee schedule is changeable by the select board. The question becomes, if there are, like, addressing is in the ordinance, but a fee was never charged for it.
Can you
So
add
that
it?
would be the second one. Can you now establish a fee for that? It's not referenced in the ordinance, unlike the others. And then there's the third group, which is the town doesn't even have any regulations for cell phone towers. So can you adopt a fee in some towns like $8,000 to review one of these?
Without an ordinance.
To approve it, without any ordinance
Exactly,
provisions
right.
for it. So there's 3 classes. One that was in here, clearly they would say, yes, you can change the fee, adopt the fee, whatever you want. If it's not specified a fee in here, that's a questionable one. Can you now apply a fee where you've never specified it in the ordinance? And then clearly where you don't even have any standards for it, that would be even more questionable about whether the select board has authority to now establish a fee of $8,000 to review a solar farm. So he has asked me to contact Maine Municipal Association legal staff to get an opinion. And I'm going to copy to them all the provisions, the ordinance and the fee schedule, and ask for their direction.
So it sounds like we're working towards this.
Yeah.
So
Yeah.
that's,
And the goal would be, the hope, maybe, hope not being a method, is that they would come back and say that the 2022 ordinance allows you to set fees. It doesn't say
Yeah.
they already had to be in there or whatever. If not, then it's those, and you're right, we need to get going, because, for instance, we are raising, if we raise our fees $1,000, which I think is a recommendation by the code enforcement guy, we would still be lower than anybody else. And for the town of Durham last year, that was a $30,000 plus up,
Yeah.
because we had 30 permits. And so at $1,000 a house more, that's a big chunk of the code enforcement officer's salary and costs. And we would not necessarily get into, we think you should charge more from electrical permit or whatever it may be.
Right,
It would
no.
be just changes the ordinance that are necessary to implement this.
yeah, I don't think it would be much work for us, right? Like this,
No, I
this
don't
fee
know.
thing, maybe a review if we wanted, but that would,
And if it was an ordinance change, I suppose we'd have to have the public hearing.
the or,
And it goes back to the issue of
If-
how many warrant articles for land use can you put on one town meeting agenda?
Why is it a land use warrant article?
yeah, I don't.
It's just the select board.
It sounds
Right.
like a
It could
process.
be.
I don't think that this is a land, like the fees, just the fees.
I don't
Or a
either.
We're
warrant
not
article
talking about
period.
radio tower ordinance or solar ordinance. We're talking just the fees, right? That wouldn't be,
That we could be doing nothing. I mean,
right.
Right.
the selectment would have to,
That's what I'm
Pick
thinking
up the
too,
slack.
is that there's really,
I'm okay with that. Hopefully there's nothing.
So we'll need to see what MMA says. If
Right.
it requires ordinance language amendment, then we're gonna
possibly
have to
if
do that.
then that's a whole, yeah.
So one other area that, with adoption of the change on the resource protection, with bringing people out and bringing other people in, new landowners that are now in resource protection. The only option, it appeared to me, the only option they have to challenge that is going to the appeals board. And going to the appeals board, there's a $70 fee. I'm questioning whether that fee should be applied. Because they're questioning, if a landowner goes out and odds are they're going to have the property surveyed.
Mhm.
And if they've expended $5,000 or $6,000 to have their property surveyed, now you're gonna say, well, you've proven your case, and now, but to prove that and to get it changed, you have to go to the appeals board and there's a fee.
I don't think we're in the business to like say certain uses you don't need to pay, certain
Don't want
uses
to
you
do.
do. Yeah, I don't,
What
Although,
kind of survey you, like, most of the comments I heard were people who had existing houses, existing property within this designated area. So you would think that they've already had a survey done on their property.
You would hope so.
You would hope so, right? So
No.
why would they spend another $5,000 on
I think
survey?
the issue is we've added the resource protection thing creates new areas on home or land that was not in resource protection before.
Mhm.
So that to me is something to consider about a waiver or whatever for those folks. So
Is that, yeah, that's what you're saying, right? We added this new,
It's the ones that have been added, and those people are the ones that are more concerned now.
I mean,
I'm limited, I'm the resident coming in and saying, I'm challenging this.
Mhm.
I don't trust, because the map is not as detailed as I know my own land is, and my survey tells me this.
But is it a boundary survey or an engineer? It's more of a,
like a
not a
wetland.
boundary survey.
Finding out the boundaries, it's
Yeah.
more or less geographic and.
I don't know what the differences are between a
It could be like a
surveyor or a,
floodplain survey, like
Right.
height above floodplain. It could
Hmm.
be delineating the boundaries of the waterfowl habitat. It could be delineating the boundaries of a wetland. I don't think it's a boundary survey.
Yeah.
No, I agree.
I don't know. That seems like it would open up a lot if we did that.
I think the appeals board already has the ability to waive fees, doesn't it, for hardship? Don't we have hardship waivers?
I don't think so, but I'm not sure.
I think we have to. What
Now,
were you
let me
going to say
also,
though?
yeah, I was also going to point out that as I stated at the town meeting and in other venues, the ordinance gives the Board of Appeals authority and responsibility to review the zoning map when boundaries are in question of districts. So they have the authority and the responsibility. And it says in there that the Board of Appeals review can be appealed by a landowner, applicant, but it can also be requested by the select board, the planning board, or the code officer. So I think in some cases, maybe those are the ones that you're thinking about, where this new map puts a whole area, and the beginning with habitat, particularly the 6+, it was what they call a rasterized layer of the GIS, which is the squares. And I, through the GIS, basically smoothed that boundary. But the actual boundary of that is somewhat indeterminate in terms of, if you go out on someone's land. So that might be an example of where if the code officer works with the landowner, they bring someone from Inland Fisheries and Wildlife down to do a review of the situation and say, look, where on this property does that, beginning with Habitat 6+, begin and end? And I do know, and one of the property owners who was affected by that, one of the maps has been updated, the undeveloped habitat blocks. And if you look at the undeveloped habitat blocks map, Inland Fisheries and Wildlife, beginning with Habitat, have carved out around the existing homes, the cleared area, in their analysis of how many acres. And I did talk to Joe Roy after the town meeting about the concept of going through, looking at the detailed map on individual properties, and for the resource protection, carving out the existing home sites from that, so that people who currently were in before and the ones that have been put in wouldn't have to go to the Board of Appeals to apply for the 30% expansion or the 50% or more expansions. And you could,
What did he say to that?
Joe thought it was a viable idea to look at. Because again, Inland Fisheries Wildlife, beginning with Habitat, do that with their undeveloped
Yeah.
habitat.
So what you're
blocks.
saying is using more data, but more specific,
Yeah.
right?
Yeah.
Like taking this,
Because right now, if you're in the resource protection for any reason, you cannot
It's-
expand,
it's
you
like a
cannot do
broad
any
thing.
expansion of your buildings without going to the Board of Appeals or the Planning Board. And what I'm concerned about is what you're going to see happening when people do that, is you're going to go through the conditional use criteria. Is it drainage? It's not going to cause drainage problems. It's not going to cause traffic problems. It's in scale. And it's going to be like an automatic approval that you're going to meet the criteria for a simple residential expansion, doubling the size of a home. And so what is the purpose of going through that whole process for the board, for the staff, and for the property owner?
Well, why don't we just make it automatic? They get an automatic 30% expansion through code officer review with a building permit. That's what a lot of towns do.
That's an option.
what do you mean 30% expansion?
So I am now in resource protection. If I wanted to add an in-law apartment over my garage,
Mhm.
I can only expand 30% of the square footage of my home.
Mhm.
So it's like, say it's 2,000 square feet, you know, I can expand 30% of that to build the in-law apartment.
Mhm.
I think what George is saying is I would need to come here and say, please, can I build an in-law apartment over my existing garage?
Uh-huh.
You're going to tell me yes automatically. Most places, the bigger municipalities that I've worked with, you get the 30% automatically just through your building permit instead of having to go to the planning board.
It's an option.
Yeah,
So what's the difference with the resource protection though? Like,
Well, if you're not in resource protection, you can double the size of your house,
Right.
right?
oh,
It's
you're
like-
saying it's 30% if you're in RP.
Yes.
Yeah.
That's what you're saying.
Yes,
I see.
that's
Okay.
an existing limitation.
Got it.
Or allowance, however you want to
Got
look at it.
So that would require an ordinance change.
Yeah, so I guess the question is, do you want to have this be an issue to research over the
Right, right,
next
right,
year
right,
and
right,
propose something for the next town meeting?
I mean, I'm okay. Like, honestly, like I was all about this whole change because it's really looking at the data, right? We're really like making it more accurate. So if we can help people by looking at data at their specific lot, I would be all about that. And I might speak for the CONSCOM, but I think they would be okay with helping that too. You know, like without having to go to the appeals board, perhaps. I mean, I know most of us don't know wetlands well, but so we might not be a big help, but I think the CONSCOM could be. And maybe George with some GIS support. I'm all about that.
but in the case that Ann had mentioned, it should be a simple process for the codes enforcement in that particular case, and I feel that he should have that authority to approve that without having to go
Yeah.
through multiple boards.
I would agree, because he's just got an existing building, so
Exactly.
he's gonna add
30%.
600 square feet to
Yeah.
to your
Is there any
house.
other use besides that would come up?
I
Like, would
feel-
we want the CEO to kind of go through and be like, okay, it would be in-law apartment, it would be,
Well, if
You
it
know?
was adding a brand new building, not over an existing building.
Or attached to an existing building.
Right.
I mean, I think we're talking about, somebody wants to put up a sunroom.
Totally changing the footprint.
Yeah, I mean, if we could consider whether or not somebody wants to build a tool shed out, and I've got one they're welcome to use, where they just want to go out and build something out in the middle of nowhere, brand new, that's different than
okay,
adding a sunroom, adding,
right, I'm
That's
just thinking we
expanding
might
it.
need parameters around what we're saying here.
So
If
here's a
it's-
concept building on what Ann has just offered. So currently in the ordinance, if you are in a resource protection district and you are a existing non-conforming residential use, you can apply to the planning board for a conditional use permit to expand by up to 30%. You can apply to the as a conditional use.
Mhm.
You can apply to the Board of Appeals for expansions over 30%. And that has a separate set of criteria, mostly seem to be almost like in line with the aquifer protection or something. So Ann's concept would say, allow the 30% expansion
Without-
by right
Right,
through the
without a
code
CU.
officer, not have to go to the planning board for conditional use. Anything over that, go to the Board of Appeals.
Right, but
How
again,
is
we're
the-
just focused on in-law apartments. That's the only use you're talking about.
No,
right?
No.
Any
30%.
expansion.
I mean, if I wanted to add onto my garage, another bay on my garage. Or
But the existing footprint, like.
well, that was my question. How is a 30% expansion defined? Is
Well,
it-
that's an interesting question, because here's the language of
Is
the
it a
ordinance.
30% expansion of the use?
It's
or-
not clear. See, this is again, part of the problem with the ordinance is
Yeah.
there's just so many areas, and we never dug into a lot of these issues. So the specific language is non-conforming, yeah, okay, so here's the language. Number one, a non-conforming non-residential use, like some of these home-based businesses, cannot be expanded, period. So whenever a new, that's a different part, expansions. Residential expansions. A residential non-conforming use, and this is under non-conforming uses, may be expanded by up to 30% of the area which it occupied at the time it became non-conforming upon issuance of a conditional use permit. The Board of Appeals may approve an expansion of a non-conforming use of more than 30% area of the area which it occupied at the time it became non-conforming. So it's not clear whether that's,
No, I think it's the, I think.
and they
it's
have
the
another
HDF.
section for structures. So the question is, but it says a residential non-conforming use, which a residential use in the Resource Protection District that doesn't allow them would be a non-conforming residential use.
So I think under that language, like using my example, I think I could build a detached 600 square foot ADU. Completely separate, different location.
Mhm.
And so I
Right.
think the question
Yeah.
is, do you want to allow that 30% expansion with just code officer approval? Or do you want it to only be like
On
an
the
expansion of
existing-
an exist? Because this is an expansion of a use. You can instead put it in expansion of a structure if you wanted. But
So-
also like expansion of a residential use, maybe a shed.
Right.
I don't give a shit, right?
Yeah.
Or a swimming pool. That's a residential use. That's an expansion of a residential use.
Mhm.
Same thing. Do we care? I don't know.
Since, I mean, I guess what you were trying to protect probably doesn't exist anyway. If you're putting in a swimming pool next to a house.
Right.
The landing turtle, unless he's swimming in there, he's probably down the road somewhere where it's quieter. Or your wetland has already probably been destroyed, building the building or whatever it may long ago. So if we make it easier for folks, I'm all for that.
So again, is this an issue that you want to spend time looking at?
I mean, it's not. When was the last time we had a request? I don't think we've ever had it. And we've got plenty of residential properties in resource protection.
Mhm.
I don't think I've ever seen a 30%. I don't think I've ever seen a 30% expansion conditional use come to us since I've been on the board.
Right. So what you're saying is it's not really important, like it's not.
I don't know that this would be
pressing.
at the top of my
Yeah.
list of problems to solve.
Well,
Yeah.
I'm just wondering what's going to be presented to the CEO.
Or what's going to be in front of the appeals board too,
Yeah.
right?
Yeah.
Per this change.
Yeah. how are they
I
gonna
liked
interpret
where
it?
you were going there. I don't know I think you might be right. Like, is it going to be that or is it going to be, what are we going to see?
Well, I think I would
What,
qualify to say that part of code enforcement's discussion with the selectman the other day was he's now making people get permits. As he's driving down the road, he sees people doing additions to their homes that there's no permit ever been filed.
Mhm.
And so these are additions to the home. So it may be a whole lot of people who are just cheating, not to say that we're going to suddenly have 50 people, but perhaps we have a
Yeah,
code
could
enforcement
be.
guy who's.
Yeah, it may well be the people that said, I'm not going to the board. It's not worth it.
oh yeah, that's,
Right.
we laugh,
No, right.
There have
I
been people
wonder
that
if
come
we
in.
should maybe like just hang tight on this and just see what shakes out.
They have a path to doing it. I do agree that eventually we should make it simpler if we can. I don't think this would be my number one priority if I was
Yeah, I think
because I don't think we're gonna see a lot.
Yeah. If we do start to see a lot, then definitely.
Alan will bring it to our attention.
Okay,
The
so
bigger picture answer to your question, I think we need to prioritize.
Yeah.
What we really want to tackle.
I agree 100%.
There's several things on the table for sure.
are there any others? So we still have on the table the affordable housing thing, perhaps solar farm, cell tower, new constructions, not in a resource protection area. Are there any other areas that we think are a major problem?
May I have a month's worth of time to look at the comp plan to
No.
see what I
No, now you got to hear from you now.
Continue.
What- So my thoughts are that, and I have our notes from when we were talking about all these different ideas. I do think going back to the comp plan and looking how they align with our current ordinances, specifically regarding, because there's a lot in there, right? We can't handle everything, but specifically regarding subdivisions and residential growth, the growth impacts, which aligns with what we were just trying to get past, but we didn't put in front of the town, which is now kicked to 25, right? 2025. The
Affordable housing?
Yeah, affordable
No, I
housing.
mean, there's
Not yet.
bills
There's-
there's bills.
Sorry,
before the
sorry,
legislature.
potentially to be kicked to 25. I think that we need to handle that, even if it is kicked to 25, start now
Let's be prepared
and be
for it.
ready. So, in that we can kind of marry that with the comp plan. Like, what did we say in the comp plan? Like we were talking about before, and then we tabled it. So that I think is one. And then the subdivisions.
Sorry, I
Yeah.
agree that that's a higher priority. Does anybody know whether or not this is actually going to be pushed to 2025?
So there are two
What's the
bills
gut
that,
on that?
Hearing on it tomorrow.
yeah, there are two bills. I've got copies of them. These are the ones that are most impactful. One is just simply to push the deadline from July 1st, 2023 to July 1st, 2025. That's all it does. The second one pushes the deadline to October 1st of 2023 and says exempt any town under population 10,000. So that would
So if, yeah,
Be a
so
big-
if the
that would
first,
be
is
a
the
big
first one on
change.
the floor, the 25?
be both.
Does it
didn't-
matter? Like, because if it gets pushed to 25, then will that one go up for a vote too? Do you know what I'm trying to say?
Yeah, we don't know. What I saw on this legislative website was that I didn't see 214 because it didn't say anything about affordable housing. So it's just
I see.
change restrictions.
So we'll know more next meeting.
Yeah,
Yeah.
I think to maybe answer the question about whether you have more time to review, it kind of depends on when we want to get a town vote on it. So there's obviously April, whatever, second, third next year for the town meeting, which may be what we're talking about with cell towers, if we go that way, or whatever other things we're going to go. The affordable housing, that may or may not take effect in the 1st of July. So the elections in the next year are town meeting, April of 2024. There is a election in
Presidential.
November for, what do you call them? Not warrants, but people who.
Referendums.
Referendums, thank you, ma'am. So that's an election. That would be a balloted election. There's a possibility of a town election separate from those because there were two budget items from 2022 that ran over. And they were withdrawn from town consideration last week because we're still not 100% sure how much the actual overrun was. So at some point in time, they have to have an election to approve spending the additional funds. So whether that'll be a separate, I doubt it'll be a town meeting. Well, I shouldn't say that. I don't know what it'd be. It'd either be a town meeting or it'd be a ballot vote. And then there is the school budget meeting in June. But the deadline, as I understand it, to get articles in is this month. And so I think we'd be very stretched to make a June election with any of this stuff.
So depending on what they say tomorrow, if it's pushed, we have some time. If
I mean,
it's not
going to be
pushed,
voted on tomorrow. There's
Oh.
just testimony on it
Oh.
tomorrow.
oh,
They have until the end of June. I think the legislature's
Yeah.
until the end of June.
oh, okay. So
And
we're
the
not-
other one to increase, to exempt smaller towns, I think just got pushed to the next session. The
So like
special session.
fall or something, or,
What special session, summer?
oh, okay. But if these don't pass, then when is the deadline
July
July
1st.
1st.
of this year?
Yeah.
Okay, so,
Which I don't think we can make. I mean, realistically, I mean, I don't see when we didn't vote on it in the town meeting.
Yeah.
The 1st of July is, if it's still a firm deadline, it comes and goes.
Yeah.
And for some period of time, we live with the
right.
state.
I
law.
think we need to do a good job at this and develop a good plan that people are going to vote for and just take as little time as we need, but also don't rush it, right? That's what I'm thinking. I mean, public input, we're going to need that,
It's a pretty extensive, we may not have to do a survey this time, but we do have to have I would think, my recommendation is a public information meeting.
Yeah,
And then George needs time to, we have a discussion. George does like he did last time, writes up the verbiage, helps put that together for us. Another informational meeting, saying this is what we'd like to do. And then, a formal public hearing sometime in advance of whatever November,
Mhm.
April, whatever vote we go for.
but I think that's one of our priorities.
So, I'm sorry, at the last public hearing, it was kind of punted. And it sounded to me as if we didn't make any decision or adopt a policy that was town accepted, we would accept the state's requirements. So let's just say that plays out. Do we still have the opportunity to change the state's adopted minimum housing ordinance? I'm sorry, affordable housing ordinance?
Okay, so I'll give you
That's a
a
really good
scenario.
question.
I'll give you a scenario. There is currently someone who has applied for permits to tear down a existing single-family dwelling with a garage. They have converted the garage into an apartment.
Oh, it's my neighbors.
And they are applying for approval of construction of a duplex. And they have asserted that under the law, they have the right to do this now. And they are going to appeal the code officer's decision not to issue the building permit for the duplex because of the pending nature of this legislation. And they're going to appeal that decision. Verbally, they've stated they're going to appeal it to the Board of Appeals. And there's another situation that's similar to that, where someone wants to move forward building multifamily within the framework of the new law. So as of July 1st, the code officer has been advised by the town attorney that if the current zoning ordinance is in contradiction of a specific state law, he must follow the state law and not the local ordinance
As of July 1st.
as of July 1st. So what would happen is that he would do that until such time as the town meeting adopts a provision that is, number one, adopted at town meeting, and number two,
Town vote, doesn't it?
town meeting vote.
A vote, but I mean, it could be the November election,
The town vote.
a town vote.
a
But
town-
it would still be a town meeting.
Right,
It would
okay,
be, it would
right.
just be, yeah. And be determined by some legal entity, either MMA or the town attorney, to be consistent with the state law. So you could do some changes, and not just accept their bare bones language, which allows a lot to happen you might not want to have happen. But you could do some refinement, but whatever you do has to work within the specific parameters set by the state for what you can do and can't do.
Which is
So-
what we're,
Sorry, can I reword? I think the question I have now is if they do get it past July 1st, we have nothing on the books.
It's already passed, it just goes
Sorry.
into effect
You know what
July
I mean.
1st.
Yes.
Yep.
Yes. And if it does go into effect July 1st, can we go through this whole process, figure out a great plan for the town and change it? Or what you're saying is as long as it's within
We
the
can change
states?
our ordinance, but
Yes.
whatever changes you make will have to meet the parameters.
Of the states already.
And there
in
is some
effect.
flexibility. So for example, in the law, they allow you to apply a per dwelling unit area
Mhm.
that cannot exceed with the area that you require for a single family dwelling. So in this case, Durham requires 2 acres for a single family dwelling.
Mhm.
You could require 2 acres for each of the 3 units that you're required to allow.
Mhm.
But currently in your ordinance, you don't. So the code officer can't say, oh, yes, you need 6 acres for this 3 units. All he can require is 2. And
Okay.
if you were to now adopt an ordinance after going through a public participation process, doing public notice as required by law, have a vote at town meeting, then you could apply 2 acres per dwelling unit, but you won't be able to without a town meeting vote.
So I say we wait, we kind of, maybe vote that this is a priority, but wait until July 1 and see what happens, or before that, and then go forward with the plan. July 1, we'll know what the parameters are if it goes into effect, or we'll have a somewhat a blank slate.
And at least wait until this legislative session ends.
Right.
'Cause these delay
Whatever.
bills may or may not go into effect.
I think there's some, at this point, whether we like it or not, we're stuck with a vulnerability. So after 1 July,
We'll
I
have
hate to
less-
use that term,
yes,
but we're
less.
vulnerable to, whatever the 2 options that or 2 possibilities you proposed out there. As long as they meet the state law, we would be stuck with it, if you will. I don't know how many of those there will be, but there will be the opportunity to do that. And then we create our own ordinance that meets all the requirements of the state legislation. That passes, and then we come back and say, now here's the rules. Here's the Durham version of that. And so there is a window of vulnerability or opportunity if you're a builder to come in and
So in addition to that, do you want to look at cell tower regulations
so-
and solar farms?
Sorry, hold on real
Because
quick. Anna wanted to ask what she thought on the housing thing.
I think it's even setting aside the state law. I think it's really important to look at this.
Yeah.
Because I
agree.
think our ordinances are too restrictive anyway. I would love to see us bring back the high development area in the downtown and decrease minimum lot size or minimum lot size per dwelling unit. Because I think it's the right thing to do. And I think housing is really important. And even further out, do I care if you build a duplex versus a single family home? I don't. And I think the comp plan supports that.
Mhm.
So I think we need to start our conversation with housing anyway.
Yeah.
And I think we can start talking about options if this applies, if this doesn't apply. But either way, I think we need to talk about housing because I look at that zoning map and we are losing all of our farmland, all of our forest land, all of our open spaces, and we're carving it up into 2 acre chunks. And that's not serving housing efficiently. It's not preserving the rural character of Durham. It's not doing anything.
Mhm.
Ideally, I would love to do real zoning, but that won't go over. But even if we can create a downtown district where we can shrink that, I think that's a great start.
Mhm.
That minimum lot size. So I think housing needs to be our first conversation priority.
Okay. And then my thoughts on the others. So cell towers, I actually used to do a lot of cell towers. I haven't seen, I don't know, are they still doing those?
We saw one on Pinkham Brook. We
Yeah.
reviewed one.
Under
Yeah,
conditional
a while
use.
ago. But I mean, are they like, I'm not,
well, I think part of it's going to depend on all of these broadband initiatives because, you're not going to be running cable, I don't think, all over this town. So, and a lot of it is going with the new technology. So
and will that
wireless.
need the cell towers, the new technology?
Well, that's an issue,
Okay.
But my concern is, again, under the Telecommunications Act, they submit a permit, you have like 90 days to make a decision.
Yeah.
And if you don't if you don't have standards, you basically,
So George, why do you think the conditional use criteria is not sufficient to address cell towers?
well, my
And-
concern is that if you apply those conditional use criteria, and we don't think about Celebration Tree Farm,
Mhm.
and we said, you said the scale of this is too big for this setting.
Well, I don't think that's what we said. That's not even a criteria, is it? It's
Yeah,
with
scale and
noise.
intensity of use is an issue. So a 200-foot tall tower next to a single family home, there's going to be some issues there of finding that it's, quote, the scale and intensity of use is in keeping with the character of the neighborhood. So it could go either way on how you decide that, but I'm just concerned that if that's the only standard you're going to apply, if you did that, I think you probably wouldn't hold up against the Telecommunications Act. But it may,
Yeah.
but
I feel like we've only seen one in like 5 years or so, whatever. I feel like solar, if we want to think about projects that are coming
The
yes.
demand is going to be there much more.
and the potential for, people to like visual effects and all of that, things that we can control or support. I think solar,
Towers have big visual impacts.
yes,
That's
but
one
I'm
of the
saying-
issues that they look
Yes.
at.
but I'm thinking we're going to get a lot more solar than we are cell
Could be.
towers.
let me ask the impact on us with either one of those, because I truly don't believe in reinventing the wheel. So somewhere in the state of Maine
Oh,
or somewhere,
there's ordinances all
there
over
are
the place.
ordinances that are Poland, Pownell, Orono, somewhere, there are ordinances that are working semi-well. Would it be possible to just take those good ordinances and say, tweak this a little bit for Durham, not reinvent the wheel? But
There
if-
are model ordinances for both of these
Yeah.
issues.
so that we're not, with the affordable housing in general, we're just starting from scratch. We got this nebulous state law that we're working with. But could we shorten the effort using model ordinances or Pownell's ordinance, or I don't even know if they have one, but somebody's ordinance out there?
Yes.
That would reduce the workload, and we could perhaps do both of them
Mhm.
if we're concerned about cell towers as well as solar.
And
Yeah.
those both require town meeting approvals.
To adopt standards for anything you'd have to have a town meeting vote.
And to go back to your point, when you were talking about housing, it sounded like you weren't limiting it to the LD 2003. You were just talking about we should focus on housing in general.
Absolutely.
Yeah.
I agree.
Like that's a part of it now, right? I think too.
And
yeah, I would-
similarly, there are, towns that have already adopted affordable housing ordinances in preparation for the July 1 deadline.
I'm
So
not
there-
sure
there
how
are
many of
some-
those that, it'd be interesting to know if there's anybody that has done that. I mean, it seems like a lot of people put their
There have
hopes
been a
into
couple of towns that have already finished. those.
Adopted?
Yeah. Was it Falmouth or Yarmouth?
It would be worth looking at how others are
Well,
doing.
there
it.
are some communities, Cumberland has adopted some affordable housing projects,
Okay.
but that's different than adopting new laws to address on a townwide basis affordable housing or other issues. I think
Still
most
trying to get a
towns,
sense of.
most towns have been waiting to see where the DECD came out,
Mhm.
just came out. They still aren't out. They're not going to release anything till the end of April or early May. In terms of here are the rules towns have to follow. So I'm not aware of anybody that's gone ahead and done it without those guidelines being finalized.
So my vote is to, yes, housing is number one, but I think we might have room to look at solar and possibly cell towers if we do look at other ordinances and if George agrees to kind
Yeah.
of lead that charge and we review maybe and see.
Yeah, and then
where
you can
we're at.
decide whether you want to move forward with it or not.
I can't think of anything else that I would put on the
Anybody
table
want to
now.
take on roads?
Roads.
I said that jokingly.
How about home-based businesses? That was fun.
I knew
It's a
we
good
talked.
one. It's a good one. It really is.
It needs to be done,
Yeah.
but whatever. That was such, I'm not interested in reading.
I'm not either. We talked a lot about subdivision issues too before.
So I will be honest, the other thing that I think we need to look at with housing is subdivision, because I think if you're building like a duplex and an ADU, you have to go through subdivision, right? Because it's 3 dwelling units on the same lot.
Yeah, and the new law specifically mentions that this does not eliminate the need to address the subdivision review issues. So,
And
Yeah.
so I think
So when we talk housing, we're talking subdivisions.
I think we need, a while ago we had talked about a minor subdivision versus a major subdivision. I would like to see us have that conversation as well, because I do think it's overkill to have to go through all of the hoops for 3 lots or three dwelling units. Forget it, 1 lot, 3 dwelling units. Our review is a lot for that, and the road standards.
I'm gonna just pull on your chain.
Well, but it all feeds in,
Your
right?
specific
It does all
chain.
feed
Minor
in.
versus major. So it does, I think it's a little bit of a domino effect.
Well, and it is something, well, that's true of affordable housing because we got into the
Yeah.
whole, all of a sudden you're 3 units on it. You have to pave the road. What do you have? There's more of it. I mean, it's a pretty,
Yeah.
is it a condo? Is it, all those questions that came up that we kind of, went, okay, we're punting this whole thing. That we need to have part of that discussion. Are they rentals only? Can we limit it to rentals only?
Yeah.
And so, and I think that housing in general is one thing we need to consider is a good issue to take on, but it's a big issue. And so if we decide that we want to increase the density in this area, and then not so much out in the other area, that's a more emotional issue perhaps than just following the state.
Oh yeah, that's a
You
big.
know,
That's
you
a
see what I'm
big.
saying? Not to say we shouldn't do it, but that may push the whole affordable housing issue off till April and may preclude us from, not saying we should, maybe it's better to wait till April and come up with a good housing solution versus try to rush something for a November election.
I mean, the way I see it, if you want to keep things the way they are, you put a minimum lot size per dwelling unit of 2 acres, which is ridiculous in the downtown,
Like,
right? And that's fair and equitable for everyone. It keeps the status quo as close as we can get it. But it's not the right thing to do.
And then the challenge you got in the downtown, and I call this the down, is that
Yeah.
when people come visit me, as we go past Gedney, I say, well, you're not passing through downtown Durham.
I know, right?
But a big chunk of downtown is historic district.
Mhm.
And so whatever we do, you know, with the historic district rules have an impact on what, you know.
Which is another issue that we haven't discussed yet, but I've been working with the Historic District Commission for the past few years.
Mhm.
And the current regulations that the town are not anywhere near appropriate for the town's situation in terms of historic structures,
Are
as
you
well
saying-
as
sorry.
well as the town's capacity to do historic preservation reviews.
So are you
things-
saying we're too lax or too?
Okay, so the basic picture that you have is you have a historic district.
Mhm.
Is basically the Southwest Bend Historic District. That has an ordinance and a process that's the same as downtown Portland,
Mhm.
Castine, Thomaston, communities where you have entire neighborhoods, Yarmouth, of very historic structures. So that ordinance was just copied and pasted from some of those communities, and it sets up a historic district commission, and any changes within that district have to go through a process for determination of consistency or appropriateness
With the state.
with the National Register guidelines for historic preservation. And a lot of those issues, you know, and people get really, really upset with, you can't get a clear answer.
Mhm.
It's like, you know, can you replace this window on this building or not? And it says, well, if it's deteriorated to the point where it's unreasonable to do it, then, and I attended a conference because I was working with them of Maine's, like 50 of the people that are experts in this, people that are on commissions, architects that deal with that. And they had a case study from someplace down in Georgia, I think it was. And they had all these experts reviewing an application to put a parapet wall on top of a structure that they were renovating. And they talked about, you know, this was built in the 1920s. And at that time, this was a motif that they allowed. And they found some of the pieces under the deck. And so they wanted to put it back, but they couldn't find any evidence that that building ever had it. And so at the end of the case study, they said, okay, now everybody, you're on the commission, you vote. Out of those experts, it was a 50-50 split on whether it met the guidelines or not. And the ordinance itself calls for, on the Historic District Commission, people with specialized expertise in architecture, engineering, historic preservation, urban planning. And there's never been anybody on that Historic District Commission with any qualifications, not even close.
Mhm.
And so you have lay people that don't really understand completely. I don't even understand it as long as I've been doing this in terms of what can you do and what can't you do. So that's an issue.
Mhm.
The town does not have the resources to do that and do it right. Secondly, there are 10 buildings in this community that have been determined by the Maine Historic Preservation Commission as either being listed. Those are the Bagley House, the Osgood House, the West
Methodist.
Durham Methodist, Union Church, and Shiloh Temple are listed. The Friends House is eligible for listing. The house next to Union Church is eligible for listing. The house on the corner across from the gazebo is eligible for listing. And there are 2 homes, one of which is right next to the subdivision that was approved, and the one across the street, those are eligible for listing according to Maine Historic Preservation Commission. So you have 10 scattered individual sites.
Mhm.
You don't really have a district. There are only 3 in that district, 7 outside of it. And the code officer and the planning board are supposed to review any project within 1,500 feet, a quarter mile of any of those 10
Any
properties.
project, like any, like a
and
building
determine
permit.
whether or not what they're doing is consistent with the Interior Department guidelines for historic preservation. That's never been done. I don't know how you do it.
So where is the historic preservation group on changing it? Are they in favor of changing it?
So I worked with them for a year and a half in trying to address these issues, these structural issues and organizational issues. It came to the point of making some recommendations in a report that I provided to them. And that recommendation was to eliminate the Southwest Bend Historic District and instead focus on the 10 individual sites, scale down the scope of review from a quarter mile to the abutting properties and those properties themselves, have the code officer, which he currently has to administer it, do reviews of those and get an advisory opinion from the historic district committee, not a commission, and get an advisory opinion from the Maine Historic Preservation Trust on whether what is being proposed meets or does not meet the guidelines. And in March of last year, the commission voted to go forward with that. 2 meetings later, they basically did a 180 and said, no, we don't want to eliminate the commission. And they want to expand their jurisdiction to all 10. So it's kind of at an impasse right now. And the question is, where do we go from here?
So what about asking them to lead the report?
They are intent on moving forward with some level. The question will be, we've got the Conservation Commission been working on resource protection. You folks, it's very important that these things be coordinated.
Yes.
And that all the groups that go into the town meeting are on the same page
Yeah.
as happened with resource protection. If not,
Right.
it's just going to be a colossal waste of time and effort.
I'm all in favor, like historic resources are important resource for sure. I'm all in favor with having them lead where they think we should go with you supporting,
Yeah.
like you did with the ConsCom, and then coming to us or whoever at select board and presenting like a draft.
So one of
idea.
the ideas that's been floated, which I think I've mentioned to some, if not everybody here, is the select board and town manager have talked about forming an ordinance committee. And the purpose of that committee would be to look at all of these issues and competing issues and limited resources and try to prioritize what should the town be doing in terms of addressing these issues. So that committee would consist of the leadership of the land use oriented committees, the Planning Board, Board of Appeals, Conservation Commission, Select Board, and Historic District Commission. Did I mention that's like 5? Come together after town meeting and review what happened at town meeting, review like your list of issues, Historic District Commission, Conservation Commission, Board of Appeals. What are the issues that we need to address at next year's town meeting? Prioritize because you're going to be competing for my time with Historic District Commission, with Conservation Commission, with Select Board, and prioritize what are the issues that need to be addressed, and then over the summer identify which entity within the town government structure, committees, volunteers, should be delegated with over the summer looking at this issue in depth and come back after Labor Day with a proposal for moving in a certain direction to present at town meeting. And then have that ordinance review committee say, yes, let's move on this one, let's not move on that one, but get all of the groups in the government structure to agree on that rather than the planning boards going in one direction,
Mhm.
Historic District Commission in another, select boards in a third. We've seen how that works.
So how would that look? So you all the heads get together and you talk about all the issues and then you decide on the issues to go forward with, right? Then who works on those issues?
So, for example, you asked the Conservation Commission to deal with the resource protection realignment.
Mhm.
Housing is an issue. What group is best suited? Maybe it's not just the planning
Who
board.
picks that though?
Who what?
Who's picking all these things?
I'm suggesting the ordinance review committee and select
okay.
board would agree, let's delegate housing to the planning board,
Okay.
but let's
Okay.
see if there's some other interest in the community
Mhm.
that could work with them on the summer over it.
But your thought is that the groups have the summer to work on it and they come back Labor Day with
With
their
a
plan.
white paper proposal for here's what the town we should look at doing.
I will, having attended, and no offense, the Historical Commission has, and I don't mean this in a mean way, has an agenda. And I think they're going to be very hard, very not open to change. So I think if they want to take on changes, then they can take the lead at the direction of the selectmen. I think that's one of those that our role, certainly we can attend, those who want to can attend their meetings. But I think we would sit back and we are the only ones who can run a public hearing. We would then run the public hearing, very similar to what we did with the Conservation Commission, but even less of a lead.
Mhm.
So
I
my
just want to
feeling,
let you know that's in the horizon,
Yeah.
Mhm.
possibly.
but I'm just saying that I think if that one is going to be a long, strenuous project.
But correct me if I'm wrong, the Historic Commission was voted to exist by the town at some point.
Yeah.
So we, okay.
I'm not saying we, eliminate them. That's not my point. My point is I think it would be a lot of effort. And I think if they want to expand their district, if they want to do those things, they're the ones who should take the lead and sell it to the residents. We would be the impartial public hearing. That's my opinion.
Okay.
So.
So I guess.
So
when-
at this point, they haven't, and they should bring that up through the selectmen to see if there's support.
Or an ordinance committee, if such a committee is formed.
So, I mean, it's already April. Are they thinking of getting on this ordinance committee soon? Like,
We just
just
had a town
thinking-
meeting on Saturday, so.
Right. Okay. So, I mean, I think I
Gary,
like
the-
that
The
idea.
town manager I've provided him an outline that
Yeah.
pretty much along the lines of what I just described. So he's going to be discussing that with the select board,
Okay.
whether to do that or not.
Okay, and that would be John participating in the ordinance committee, right?
I think, yeah.
Yeah, and then so you would just present, if it was, say, before our next meeting, the things we just talked about.
Yeah, I mean, I think at the point we're at right now, if the meeting was tomorrow, I would say the planning board is going to take on housing, solar and cell. I mean, if that's kind of the consensus I heard.
Those are the
today.
issues that you've identified that
Yeah.
need to be addressed in the short
Oh,
term.
we didn't hear from Tyler.
We, I was just gonna say that housing, there's been like, I'm gonna say at least a dozen different topics that were brought up today about housing.
Yep.
So it might, before we just say housing, maybe we say what specifically we'd like to look at.
I'm good with that because I think, and I agree with Ann that we need to do some things, but we have this window of vulnerability starting at 1st of July. So how do we fill that? And then, but at the same time, and whether we're ready for next April or April 2025, we talk about, because I think anything that's done in downtown Durham is going to run in the face of the historical district. And
The other limitation is the lack of public utilities to do a growth district.
Right,
It's-
that was the whole
You don't have
reason.
public water, you don't have
Right.
public sewer, so
So we
doing
can't
higher
do a
density
growth.
That was
housing.
one of the reasons it was broken up.
Right,
yeah,
we
it's-
can't do an
it's-
official growth district.
Well, it's just a very hard challenge to do it with the
We can't.
limitations of no
We
public.
can't, we
water.
don't have infrastructure.
Well,
That
you
would take-
could do, under Maine law, you could
Right.
do, basically, you're sitting on top of an aquifer here.
Well, I
So
know
you
we
could do public water systems that would allow you to do some higher density housing.
Yes,
but
but we
But
can't.
even with a half-acre lot, you have enough room for a septic. Right? If you went from 2 acres down to half an acre,
You're probably looking at needing to do public wells if you're going to go with that, because you have to have separations between septic systems and wells. Trying to fit a well and a septic system on a half-acre lot at higher density is a real challenge.
Yeah, so I mean, to Tyler's point, I think it's a really good point. What do we want to focus on housing first? Or,
Yeah, it doesn't have, you don't have to crack the whole coconut in one meeting.
right.
Or one
Right. We don't have to
process.
talk, yeah, we don't have to
Comprehensive
think-
plan right now sets a pretty clear direction for the town, which is the status quo, as you described. Good, bad, or indifferent.
Yeah,
That's-
like
that's
look
where
at
you
the
are.
comp plan and,
To do a growth district, you're probably looking at having to updating your comprehensive plan.
Right, because we pulled it out.
You
right,
just
we pulled it
repealed
out. So like focus on what the comp plan says.
Yeah.
Or
The
look at
comp plan
that
says
and then, but
pull it out.
also,
So now we have to.
well, yeah, so look at the comp plan and then also know that this affordable housing thing is out there.
Yeah.
Like,
But I think it's worth looking at. Do you want to have a higher density area, whatever title you put to it, growth district or whatever? And if you do, if a half acre's not enough, is an acre, or Mr. Developer, if you want to do a subdivision, in the backyard of the town hall, here's what, you're gonna have to provide water. You figure out how to do it and the cost of doing it.
I think it's totally worth exploring, for sure.
We're not gonna solve it tonight.
Yep, I agree.
What?
I mean,
Right.
like
we're
easiest,
not?
honestly, easiest thing is to require 90,000 square feet per dwelling unit outside of what is not the growth district. And then just keep it 2 acres and you can have 3 dwelling units. You're not even reducing it to a half acre. That meets the standards for the state law. I mean, I don't think it's very thoughtful, but that's like a blunt object to get at some of it and comply with state law.
Nobody said the state law was
I know.
a well-written document.
State law was designed for Falmouth. let's be
Hey, I
honest.
resemble that remark.
Yeah.
So I think maybe, again, if those are the things that I would think that we brought up, I don't know that, we need to bring in a lot of people to help us with solar or other issues. We would certainly get plenty, we got
we got
lots of
George.
input last time.
got
We have George,
Yahoo!
and I'm, as I said, a huge believer in not reinventing the wheel. And as is George, I'm sure to keep it as simple as possible to get us there.
Planning is one of the professions where plagiarism is a virtue.
Okay. All right, well, in that case, I think I need a formal motion to get out of here.
So moved.
Oh, can we just, sorry, I'll second that. I'll second the motion.
Actually, you're right.
The
Should we
next-
talk about workshops?
Mhm.
To do this work, and not that I want another meeting, because I don't even make one meeting, but should we talk about doing this in workshops instead of the regular meetings?
Definitely.
At least to focus on housing, right? Like to narrow that down for the ordinance committee discussion, right? Maybe to do that.
How do we schedule them without, like the Deer Creek thing? How do we can't just blow them off. I mean, so if they're not ready, if they're ready next month, we get a decision, we're done, we move on. We have no other applications at this point for June, not to say that we
So
don't.
here's a suggestion. We had done this before, is that basically if you have an application, focus on that at the regular meeting. And the second Wednesday of the month, instead of the first, a week later, have a workshop. But if there are no pending applications, do it at the regular meeting. If there are, then have a workshop. And you want to do that on a monthly basis for the time being?
Mhm.
The only thing is, I would say is, can everybody make, if we do have applications, we now have to make 2 meetings a month.
Well, someone might make the regular meeting, but not the workshop.
And what you're saying is if Deer Creek doesn't come back on next normal meeting, we talk then, and we don't
Or if
have
they
the
you
second
get through
meeting.
them the next meeting, and then you don't have any other applications, just use your regular meeting.
We don't need a second meeting that month.
Right.
Right. Yeah. And I think we can just talk about it during our next meeting.
Yeah, I'm
You know.
fine with, I just.
Yeah.
A caution is we need,
Get ready.
everybody needs to get, we're now going from 1 to 2. And that was a challenge. And I appreciate everybody doing that. December, January, February, March, we had lots of meetings. So those of you who weren't in Florida.
Don't like Florida.
All right, so
I'll
I
add
like,
that.
I like the
But it
plan.
was fun to vacation.
We can talk about that next time. So I think I have a motion on the floor, but I lack a second. Oh, we have a second. Raise your hand.
If anybody
We can-
wants copies of those
we can leave.
bills.
Thank you all very much. Thank you for the work getting to those